John Romans et al. Versus Daniel Kalk et al. And each party will have 15 minutes to present their arguments. Probably helpful if you identify yourself and the party you represent. Of course, the appellant may reserve up to 5 minutes for rebuttal. As you probably know, the arguments are recorded and are posted on the court's website, as well as our YouTube channel. So try to remain behind the podium and keep your voices up. And with that, we've read your briefs and we're ready to proceed when you are.
Very good. Thank you, Your Honor. May it please the court, counsel, Christopher Tipping on behalf of the appellants, John and Patricia Roman. I would like to reserve the 5 minutes of time for rebuttal. And Your Honors, I'm here today standing before you to urge the court to reverse the trial court's decision of summary judgment in favor of the appellees and furthermore to sustain the appellant's assignments of error. And as the court well knows, having read the briefs, this matter involves the ownership of 2 adjacent properties in Hudson, Ohio. And there are several items with regard to the facts that I want to briefly touch upon because appellants believe they're very important. At all times relevant to this case, the Roman parcel, which is 7005 Walters Road, was and has been a separate parcel from that parcel now owned by FOPCA, the appellees. The Roman property was never run collectively as part of the Boston Hills Pet Cemetery. Despite what the trial court indicates and what appellees have argued, that has never been the case. What you had, and it's in the record, is these two, there have always been 2 parcels. And for all times relevant to the matters before this court, you have 2 separate parcels. At one particular time, those parcels were owned by the Boston Hills Pet Memorial Park, an Ohio general partnership, owned by Albert and Robert Razzie. In 1989, that general partnership filed a declaration of restrictions to a portion of the property. For purposes of, as the declaration of restriction indicates, desires to restrict a portion of said real property described below with the legal description as for use as a pet cemetery. And then there's further language in the restriction that says the restricted property shall be held, used, occupied, and conveyed only for such purposes as are usual and normal for the operation of a pet cemetery.
Did that restriction cover your client's property?
It only covers a 1/4 acre of what is a 10-acre property, Your Honor. And that leads me to my next point with regard to the history of these properties. In 2008, and this was a point of contention through discovery in this case, and it was ultimately produced. The trial court asked for additional briefs on the lease, and it is part of the transcript docket number 139. In 2008, April, Boston Hills Pet Memorial Park, as landlord, executed a ground lease agreement to Boston Hills Pet Cemetery, LLC. In this ground lease agreement, it indicates the landlord hereby leases to tenant, and tenant hereby leases from landlord certain land and improvements thereon commonly known as the Boston Hills Pet Memorial Park, and more particularly described as Exhibit A and attached here too in the document. An outline of the premises that's leased to be operated as the pet cemetery is set forth as Exhibit B. Exhibit B sets forth, and we have this in our brief, but Exhibit B sets forth the boundaries of the leasehold interest that was leased to the Boston Hills Pet Cemetery, LLC, for purposes of operating a pet cemetery. Mr. Roman's property, my client's property, is entirely and completely outside of that leased area for purposes of running the Boston Hills Pet Cemetery. The leased area...
Is it your position that the lease invalidates the restriction then?
our position is this: the lease clearly indicates, and let me answer that this way, Your Honor, back to the first page of the general lease. It indicates Exhibit B, and then it says a legal description. The premises are so the premises leased are part of real property owned by landlord and dedicated to the use as a pet cemetery in accordance with applicable sections of the Ohio Revised Code. That's 961, upon which the restriction was originally filed. A legal description of such dedicated land is set forth as Exhibit C in the ground lease. That's the same legal description that's in the restriction for 961. And then it says, a copy of the Declaration of Restrictions applicable to the pet cemetery, of which the premises is a part, is set forth as Exhibit D, and that's this same restriction is attached to this. Our point, Your Honor, is this: at no time, and here's the importance of it, at no time was the Roman property a part of, or a part of this lease for purposes of the Boston Hills Pet Cemetery LLC. In addition, in this ground lease, because the Razzies, the Ohio General Partnership, owned a significant additional portion of that land, which includes the Roman property now of 10 acres, they state specifically in here that any and all portions of the land that was not leased to the Boston Hills Pet Cemetery LLC, portions of the real property described on C, Exhibit C, that are not part of the premises, at the landlord's election at any time during the term of this lease may be removed from the restrictions. So they in this lease, with regard to my client's property, they indicated that they had the right, and they got a contractual agreement to remove the restrictions under 961, and the tenant agreed to comply with that and to not dispute that. What we have here, Your Honor, to Judge Teodosi, to specifically answer your question, we now have allegations from the other side that there are various burials that were made at some point in time in and around the office building that's on my client's property and the barn. We've never been provided with any written documentation of any existence of that. We asked for it in discovery, we didn't get it. The trial judge even says in her order, this is typically discoverable, but I feel that it's not appropriate to provide to the other side. I want it in camera, but then it was never shared with us. And then the trial court says in the order, well, I'm reserving it for appeal. Here's why that's of crucial importance. The trial court also argued under 961 that we are supposed to secure the consent of all of the alleged burial right owners in order to remove a certain restriction. Number one, 961 does not in any place in that statute say that we have to get unanimous approval for all those individuals. It actually specifically contemplates in 961.05c that you can remove portions of the restriction. If there's evidence that there may be burial rights in situations on this small sliver of the property but not in front or not on the side, we can remove those. We weren't able to do discovery to get any of that information, and yet the trial court accepts as fact a hand-drawn map by Vivian Kalk that was created after the lawsuit was filed, where this is a Google-type picture of the top of my client's property, where she's written on here and circled 2011 a bird, 2011 a guinea pig, etc. It's in the record. This was utilized as a basis to deny our motion for summary judgment and grant their motion for summary judgment. All of these alleged burials that this Ms. Kalk, who was the secretary of FOPCA, indicated were done in 2011, and were all done during the time that this property was in foreclosure, and were also all done during the time when this lease was in place, when the ground lease was in place that said, your burial park and cemetery is here, it doesn't include the property which was now the Romans. Obviously the property went into foreclosure, Mr. Roman bought it. There is, as you're correct, Your Honor, an encumbrance on the property, 1/4 acre, that indicates that it would be used for cemetery purposes. But the lease is important because never was a pet cemetery operated on the Roman property. He doesn't operate one. 961 doesn't contemplate a situation where you've got an owner who's not an operator. But that's what happened in this case. The trial court even said, we've got a unique situation here where ownership and operation is now separate. Well, what did the trial court do? The trial court, impermissibly, it's our position, totally accepted all of the factual assertions of the other side, prohibited us from finding out if they really have a legitimate burial right, if there was any consideration made, if there was money transferred, if there was anything in writing. We don't have any of that. We couldn't get any of that. And yet we're denied our rights under 961 to seek to remove this restriction, at least in certain areas or in all areas, and they're granted summary judgment. Now,
Counsel,
sure, yes, Your Honor.
when you're talking about portioning out part of the property, you're speaking like if there is a bird buried there that's only 2 feet, that you should be, if you get the owner's permission, you should be able to take that 2 feet and remove it from the restriction?
Well, what I'm saying, Your Honor, is this. I mean, that can happen. I mean, the statute contemplates if you get permission, then there can be a disinterment and a reinterment somewhere else. My point with regard to the apportionment is this. The evidence, at least that they claim is evidence, it only has burials allegedly around a portion of the office building and the barn. There's also a few old headstones up by the roadway on Walters
On the quarter
Road.
acre.
On the quarter acre. The rest of it, there's no evidence of anything. I mean, there's no evidence of any burials of any kind. So our position, we had the right to get the information that we wanted to get and to proceed under 961, to have the trial court remove that restriction, at least from those portions where there's no evidence of any burials there. That's what I mean by apportionment.
All right, Mr. Tipping, I have to cut you into your 5 minutes, so.
Thank you.
I've got that 3:38 left. I didn't want to interrupt.
No, thank you. I will,
I'm assuming you want to reserve that.
I do, thank you, Your Honor.
All right,
I'll be
thank
back
you.
in a minute, thank you.
All right, and the appellee will have 15 minutes.
Good morning, Your Honors. My name is Donald Drinko, and I represent the appellees in this matter, Mr. Kalk, and the Friends of Pet Cemetery Association. And I don't want to jump into some of the issues that have already been covered. I do want to cover the lease issue because I think it's important to discuss it. But I do want to kind of give you the overview of this case, and that is that with the exception of some interesting facts that kind of make this case a little peculiar, this case really involves a fairly straightforward application of what I would argue is a clear and unambiguous statute. Revised Code Chapter 961.05D, and the issue of whether the appellants in this case who purchased a piece of property can lift a restriction that was in place dating back to 1989, and whether they satisfy the 2 provisions of that statute which would allow them to lift that restriction. Now, I would argue, and I think we've done so in our briefs, that there are some facts that are really not in dispute in this case. For example, the property in question, purchased by Mr. and Mrs. Roman in 2014, was originally part of a larger parcel. I would take issue with counsel's statement that it was never used as a pet cemetery. These parcels, both the parcels that were purchased by the FOPCA and the one that was purchased 2 years later by the Romans, were once part of one business that's been operating as a pet cemetery continuously since the 1940s. And those parcels came into foreclosure in 2012. The 2 parcels that were sold to FOPCA, which was organized at the time to manage the pet cemetery, to maintain the ongoing operations of the pet cemetery, those 2 parcels were sold for about $6,500. Mr. Roman came in later, 2 years later, and bought the parcel at issue in this case for, I think it was $108,000 out of foreclosure. There's no dispute that the restriction was put in place in 1989 by the former owners, the Rossis, that it was properly executed, properly recorded. That's not in dispute. There's also, I would argue, no dispute that there are animals buried on the parcel property that was purchased by the Romans in 2014. If you look at the briefing, there seems to be some question about that and questions of evidence, but there are roughly 25 graves clearly marked in the front of the property. There's also animals, and evidence has been adduced that there are animals buried in the back part of the property. There's been some discussion in the briefing about Block 1 and Block 2. That's really a fiction. This is really one group of property, or one section of property. I think it's less than half an acre of the 10-acre parcel. So the question then becomes, can the Romans lift the restriction from 1989 on the property that they bought in 2014? And I think there's one other important point here, and that is that it's not in dispute that Mr. Roman, before he purchased the property, was aware of the 1989 restriction. He was aware of it, he had researched it, he consulted counsel, and he ultimately elected to purchase the property as restricted. So the question is, can he lift the restriction that is in effect, that has been in effect since 1989? There's two ways to do that. One is to indicate, or is indicated in the pleadings, is that to demonstrate that there's no graves on the property, that all of the animals have been either, there were never animals on that part of the property, or that they have been disinterred and reinterred. That's not possible because, as I said, everybody agrees that there's animals buried there. The second provision is whether or not they can secure the permission of all of the holders of burial rights to lift the restriction. In this case, as Judge O'Brien had indicated, there's no dispute that that's not possible either, because there have been affidavits filed by individuals both in the back section and in the front section who indicated they would not agree to lift the restriction. And so Judge O'Brien concluded at that point that there are no questions of fact, that they cannot satisfy their burden under 961.05, and therefore the restriction can't be lifted. Now,
why can't you apportion it out if the burial of the animals are, let's say, in a 1/8 section, for instance? Why couldn't that portion be kept as a pet cemetery and the restriction lifted from the other portion?
well, I think that they could. The question of whether or not they would be able to do it in separate sections is first of all, presupposes that it is separate sections, and it's really not.
That was my presumption, yes.
Yeah, and it's really not. This is a continuous overlap, if you will, from the previous owner's use of the property. And really, what you're talking about is a section that, the front section has gravestones dating back to the 1940s, and I'm not sure, I think there might be even something in the record that indicated that the Romans were okay with having those gravestones in the front. I mean, there's a cemetery next door with 14,000 animals buried. So, obviously there doesn't seem to be a lot of problems with, the existence of a pet cemetery per se. But the problem is that there's also animals buried, 2 horses, there's a mass grave of 50 dogs, and some other pets that were buried later on that are in that back section as well. And our contention is, if they were to secure permission or authorization under 961.05 D2, then that would be liftable.
No, but my question to you was, as a hypothetical, let's say that all the animals are buried like in 1/8 of the 1/4 acre
Okay.
in a certain section. Okay, that would be able to be apportioned off, say just in the back section or whatever. Why would they be prevented from removing the restriction on the other portion of the property, the majority of the property?
I think if there were a restricted, let's assume for your
That's what I'm asking.
example that the Block 1 and Block 2 characterization from the appellants were accepted, and that in Block 2 there were no animals buried there. I think they could lift the restriction in that section under D1 by claiming that there's no animals buried there.
But isn't that the opposite of what the trial judge said?
I don't believe so. I think what the judge just said in this case, I'm sorry, Your Honor.
No, I apologize. I asked you and then I talked over you. Go ahead.
I think what the trial judge said and concluded in this matter was that in both sections, there was evidence that there was animals buried, and in both sections, there was evidence presented that they didn't provide permission. If Your Honor is asking if, as you opined or asked earlier, would you be able to, for example, secure permission from one grave and secure a 2-foot portion, for example, for a bird, I don't believe that that's what the statute says is permitted. I mean, that's why it says it has to be from all owners of burial rights.
The other question I have for you is, you say there's not many disputes of fact, but you do indicate there are disputes of fact.
I don't think that there's disputes of material fact.
Okay, and that's what I was gonna get at, because right there, what you're talking about, if they say these animals are only in a certain section, and I think you're arguing they're interspersed throughout the property.
I think the evidence that was presented before the trial court, you know, specifically there was an affidavit from a gentleman by the name of Al Rossi, who was the former owner of the property. He submitted an affidavit which was provided to the appellants that he had 2 horses buried in that block 1, which is back between the buildings, that there was a mass grave of 50 dogs. There was a testimony from a woman by the name of Vivian Kalk that there were pets buried at that time. And I think, frankly, if you look at the lease issue, and I guess I'll kind of segue to the lease issue because I did want to address it, that's the argument about the lease is, well, Vivian Kalk shouldn't have buried those animals there because it wasn't part of the lease. And I would just say that the lease is kind of a red herring in this case. And I think...
Before you get into the lease, if you don't care, because I do want to hear about it, I'm sure the other judges too, but this was presented on cross motions for summary judgment?
Correct.
So were there stipulated facts?
There were not stipulated facts. In this case, unfortunately, because of the nature of the case, there was not a stipulation reached. But I think that there were affidavits filed with regard to what I would consider, and what the trial court considered the material facts, which is, were there animals in that, in the restricted area? And frankly, the contention that there's no animals there is belied by the fact that there have been these other arguments. The arguments that there are animals that were buried there but without permission, or that they had negotiated. In fact, the appellants in this case, as you know, negotiated with some individuals who held burial rights in an attempt to lift the restriction in a part, and they weren't able to secure those permissions. So I think that the material facts in this case, meaning that there's animals that are buried in the restricted area, that the restriction was valid and in place for a number of years, for 30 years before the property was purchased, that it was known to the appellants, those things aren't in dispute. To the lease, I think that the lease is a red herring, and I'll give you my reasoning. None of the parties to this lawsuit were parties to the lease. The lease in question it covered a piece of property. The appellants indicate that their contention is that it doesn't affect any of their property. I don't think it's necessary to contest that or to question that, because the lease itself, and this is vitally important, recognized the restriction. There's no legal basis for arguing that the lease could have, would have, or should have modified the restriction. There's one avenue to modify a restriction of this type, and that is through the application of 961.05. And I guess I'm running out of time here, so what I just wanted to say, is, why are these restrictions important? These restrictions are important because these animals, buried by people over the course of the better part of 75, 80 years, these are like their children. The state of Ohio recognized pet cemeteries as places where people can place their animals and not worry that someday somebody's going to argue that there's a better use for these, for a piece of property rather than a pet cemetery. That's why lifting these restrictions is hard, and it should be hard. And that's why you see, if you drive around, I know in downtown Akron and downtown Cleveland, there are cemeteries, and you think, there's a cemetery across from Progressive Field in downtown Cleveland. Why is there a cemetery there? Because the law says that those are the highest use, that those can, restrictions in a cemetery, cemeteries can only be moved through very stringent requirements because people want to be able to rely on the restriction, on placing their loved one there and knowing that it won't be disturbed. And that's why those restrictions are as strong as they are. The state of Ohio made them difficult to lift, and in this case, the appellant simply didn't satisfy them. Thank you.
Any other questions? All right, thank you, Attorney Trinko, and you have about 3 minutes, 38 seconds left, Attorney.
Thank you, Your Honor. The lease states specifically, the provisions of this instrument shall be binding upon and inure to the benefit of the heirs, executors, administrators, successors, and assigns of the parties. And I would advise the court that FOPCA purchase this property directly from the entity that executed the general release. We do dispute, I dispute what Mr. Drinko said with regard to where animals are buried and or where they're not. We were never supplied with any of the documentation. Judge O'Brien kept it improperly and didn't provide it to us, which we had the absolute right to and which your order says. And the point I'd like to conclude with is appellees would want you to believe that all they were attempting to do was just trying to keep these restrictions in place and then go about their way. They moved in their summary judgment motion to be permitted access and control of the 1/4 acre of my client's property. And Judge O'Brien, it's our position, improperly created, through her equitable power, an implied easement, or at least claimed it was an implied easement, but in the operation and in the effect of that order, she basically disengaged my clients from their property. And let me give you an example. The barn. You've got all the evidence with regard to the barn. The trial court even admits in its decision that the barn is owned by my client. And yet the trial court orders that, and the specific language I think is appropriate to reference, orders that full use and access of the barn, which my client owns, is now denied to him. The court finds that evidence does exist to support the plaintiff's claims that they're the sole owners of the barn in question. However, evidence further establishes that any portion of the barn located on plaintiff's property is also located in the restricted area. Accordingly, plaintiffs may only utilize the barn in a manner consistent with the deed restriction, and then here's the improper easement. Plaintiffs have admitted they don't operate a pet cemetery, and therefore, this is what the court orders, plaintiff has no reason or right to access, use, or maintain the barn. He owns the barn. This isn't an easement, it's a land grab. And what has happened, Your Honors, there's 2 other lawsuits that have been filed after this. What FOPCA wants to do is take that 1/4 acre of my client's property and use it for its full use and exclude my client. Yet he still pays the taxes, has to do the upkeep. And now we have a situation where there's an alleged easement that's been provided, but it excludes my client from the use of his land. That's totally improper. That must be reversed. And furthermore, the trial court was in error, and you're right, Your Honor, there were no stipulated facts. And just based upon the arguments that you've heard today, there are significant facts in dispute, and there will be other facts in dispute. Certainly, once we get the opportunity to have the evidence that we were required and deserve to have with regard to who's buried in the property, when was it buried, etc. Vivian Kalk is the secretary of the FOPCA. The affidavits that they submitted are self-serving. Rozzy is the former owner of the property that executed the lease that said my client's property was outside the lease interest. So we would ask, Your Honors, that this matter be reversed, that the easement be vacated, that if it's remanded to the trial court, that the trial court be ordered to provide us with that information and let us proceed to litigate our claims under 961 and proceed forward in that regard. Thank you, Your
All
Honor.
right, thank you. The court wants to thank counsel for their excellent presentations today. The court obviously will take the matter under advisement and will issue a decision in due course. The courts will mail the decision to counsel on the day it's released. Also, you're probably aware that the decisions are also posted on the Supreme Court of Ohio's website. Thank you again for your presentation.
Thank you.